recording now. Welcome everyone. It's just how many minutes? Okay, just 2 minutes to 12. So let me quickly share my slides and then we can start off. Okay, where is them? No, I need to start from the top. Okay. Okay, so let me. Okay, it's 12 o'clock. So welcome everyone. Super excited to have you all at the research series of the University of West Indies, St. Augustine, Faculty of Law, ADR section. And thank you so very much for creating time out of your busy schedule to be with us. So without further ado, I will first introduce myself and then go on to introduce my colleague who is a guest for today's section. So my name is Dr. Chinwe Egbunike and I'm a lecturer at the Faculty of Law, St. Augustine-UWI. So before this position, I lectured at the University of Brighton where I taught law courses. I also taught research methods and human resource management to both undergraduate and postgraduate students from 2019 to 2023. Additionally, I was Economic and Social Research Council, UKRI Research and Innovation Post-Doctoral Fellow at the University of Brighton from 2020 to 2023. And so without further ado, I'm introducing our guest, who is my colleague, Ms. Shivangelie Ramoutar. She is an attorney at law of 9 years old, an alumni of the University of the West Indies, and a national scholarship winner. She attained her Master of Laws degree with a commercial specialization at the University of Cambridge in 2017. And in November 2017, assumed the position of associate at a very reputable law firm in the Republic of Trinidad and Tobago. Her areas of legal practice at the firm included civil and commercial litigation, which involved court arrest and negotiation. She is also a lecturer at the University of West Indies, St. Augustine. So it's such an honor to have you on the show, Ms. Ramoutar. But before I properly introduce her, I've introduced her already. Before I stop sharing my screen, I need to share this just for context, because we will be looking at the Commonwealth Caribbean jurisdiction, ADR. So for those of us that are not from the Commonwealth country, Caribbean jurisdiction, it's imperative to state that we have 20 countries, of which 15 of them are actual member states. So we're going to put this under the YouTube description. So after we finish, we're going to put out the recording on the Faculty of Law YouTube page. So you would have a look at the countries which are member states and the 5 associated states as well. So thank you so very much. So let me stop sharing my screen. Welcome to the show.
Thank you very much, Dr. Megulu, for having me, and to UWI for having me. I'm honored to be here today to speak with you on ADR.
Oh, same here. So without further ado, the first question is, what is ADR and how far has it enhanced access to justice in CC, Commonwealth jurisdiction?
Well, in the vibrant and diverse legal landscape of the Commonwealth Caribbean, ADR, alternative dispute resolution, or some critics, and I tend to agree with them, more appropriate dispute resolution has emerged as a beacon of efficiency and innovation, transforming the ways in which disputes are resolved. ADR encompasses a range of processes, including, but of course not limited to, mediation, arbitration, negotiation, and conciliation. And these offer more flexible, cost-effective, and timely alternatives to litigation. In fact, the courts have recognized ADR and made provisions to promote ADR in Trinidad and Tobago in the Consolidated Civil Proceedings Rules of 2016. In terms of ADR and its essence, it really provides parties with a platform to resolve their disputes amicably outside of that traditional courtroom setting. It's really valuable in the Caribbean, where judicial systems are often faced with significant backlogs and delays. By embracing ADR, the region aims to enhance access to justice, reduce the burden on courts, and really foster a culture of collaborative problem solving in the Caribbean. But tell me, Dr. Umegbolo, how far do you wish me to speak on the enhancement to our access to justice in the Commonwealth Caribbean? Because the Commonwealth Caribbean is so vast and we've had so many advancements.
Yeah. Okay, I would like you to touch on our region, that's Trinidad. Is there any new law?
Oh, definitely. That takes me straight to arbitration. And I see that we have some law students present. So I know they would be familiar with the new Arbitration Act of 2023. I believe it's Act number 11 of 2023, which is a notable improvement. It represents an addition of Trinidad and Tobago to the group of countries in the Commonwealth Caribbean that have adopted the UNCITRAL model law, the international standard for arbitration. Trinidad and Tobago is not, of course, not only the only Caribbean jurisdiction to adopt the model law. We have Bermuda, Barbados, the Cayman Islands, the BVI, and Jamaica as well. They've all adopted the model law. And in doing so, we've moved towards the harmonization of arbitral laws in the region with that of the international standard. And this, of course, reflects the region's commitment to providing investors with preferred arbitral mechanisms for dispute resolution to avoid litigation in domestic courts. And in so doing, the spirit and the efficacy and efficiency that pervades commerce is upheld. So definitely, I'm so pleased to be able to say that we have now done away with the antiquated Arbitration Act, and we now have the 2023 arbitration legislation in force. But apart from the legislation, we also have continued efforts throughout the Commonwealth Caribbean to establish infrastructure and equip the international arbitration centers with the technological and institutional frameworks that are necessary to attract international commercial arbitration in the region. For example, the Cayman Islands introduced their procedural Grand Cayman Court rules and the International Mediation and Arbitration Center rules in 2023. And of course, the CIAB, the Caribbean branch of the Chartered Institute of Arbitrators, also plays a pivotal role in providing educational awareness and furthering arbitration of an international standard.
Oh, thank you so very much for providing such an invaluable insight. I also want to ask about if there is any qualitative data to sort of lend credence to the fact that it has actually enhanced access to justice. What are the courts like? What are the courts dockets like? Has it considerably reduced, or, do you have any clue?
Well, if we're looking at the courts in Trinidad and Tobago, the ADR pilot project that was conducted in 2013, and it was for 1 year in May 2014, I believe. Yeah. And it was championed by the Honorable Mr. Justice Vashish Kokaram Stenwas. did in fact considerably contribute towards reducing the backlog that's associated, attributed with the court's dockets. And there was in fact a report generated by the judiciary indicating on the success of the ADR pilot project. And that has manifested or enhanced into the Consolidated Civil Proceedings Rules of 2016, which makes ADR actual figment of the rules. So we now have embedded in our civil proceedings rules in litigation a recognition, an acknowledgement, and appreciation of how important ADR is in resolving disputes.
Oh, thank you so very much for that. So you pointed out the appropriate in ADR, because we've had so many scholars like stating that it is actually appropriate, and some of them still call it alternative, depending on where they are from. People from the African jurisdiction would say, well, we had always had this, we don't see it as an alternative. And of course, people from America jurisdiction would, one of the scholars I interviewed, Kevin Scudder, pointed out that it's actually appropriate. It should not be even called or considered to be alternative, because parties have the right to choose which of these methods that suit or they feel comfortable going with, or that can settle their disputes. So what is your take on that? Is this appropriate to you or alternative? Thank you.
Of course, it is my view.
Yes.
I'm not going to parrot the views of the critics. In my humble opinion,
Yeah.
I think the appropriate terminology would be appropriate without putting difference on the words. I think it may have developed as an alternative to litigation, as an alternative to the traditional mode of dispute resolution in the Commonwealth Caribbean, but it has now evolved. There are so many processes which come under the umbrella of ADR that really it's up to the parties to choose which is most appropriate for their dispute. So I think it's more of an evolution of the terminology as opposed to a hard and fast, it should be appropriate and it should not be alternative. I think it's important to, at least in the Commonwealth Caribbean and for me, to appreciate the evolution to becoming appropriate resolution.
Thank you so very much. When you talk about evolution, it leads me to the next question, the history, because I know that Justice Gafford pointed out that in Trinidad, you sort of had this history, I think in a particular tribe, about it being, sort of the main method before the introduction of litigation and reintroduction of ADR to the region. So can you sort of expand on the history and evolution of ADR in Trinidad and Tobago? Thank you.
Most definitely. In Trinidad and Tobago, we have a very diverse culture. We have persons, thanks to Indian indentureship, we have thanks to slavery, thanks to many cultures coming into one boiling pot. And by virtue of that factor, we have different traditional practices which developed in Trinidad and Tobago. So in the Commonwealth Caribbean, we have traditional practices of community-based dispute resolutions, which predated the traditional court system and predated what we now know as ADR. It was informal and it relied on principles normally attributed to mediation and negotiation. But these systems, for example, the Panchayat justice system in Trinidad and Tobago and the system of traditional village councils, both communal dispute resolution systems relied on community elders and respected figures in the community itself to mediate and settle conflicts. These methods were often used to resolve conflicts within small communities. And in fact, our legislation on Mediation Act of 2004 does in fact provide for community mediation, which nods in the direction or acknowledges the importance of these traditional practices which have developed over time.
Thank
but
you.
Of course, we have evolved.
Oh,
Dr.
yeah.
Somewhere below. We
Yeah.
have adopted various
Yeah.
institutions, the legal frameworks. So it is really a beautiful, diverse practice, ADR, in the Commonwealth Caribbean.
Thank you so very much. So I would also add flesh to what you said. The judgment of Justice Kokorama. Kokoram, yeah, in this case of Morada and Kenneth O'Brien, where he pointed out that the courts should be the last resort in settling disputes in Trinidad. So
definitely, and it's amazing that you brought up Justice Kokoram, because he was the one who championed the ADR pilot project. And really contributed towards the introduction of ADR via settlement conferences and court annex mediation into the court system.
Oh, thank you so very much for highlighting that. So let's look at the benefits. And before we go to the benefits, like, what are the challenges that we're faced, in promoting or bringing ADR to Trinidad and Tobago?
Well, over time, I think some challenges we have in fact shared with other parts of the world as it relates to ADR, and other challenges may be specific to us and to our dynamics here. One that is definitely something that's shared is the cost effectiveness of ADR. ADR, sorry, not the cost effectiveness, the awareness and the acceptance, of ADR, because there is clearly a lack of awareness and acceptance of ADR among the public and legal professions. And this can, in fact, hinder its widespread adoption. Thankfully, however, we have bodies such as the Caribbean branch of the Chartered Institute of Arbitrators. We have the UE. We have institutions such as Dialogue Solutions and the Dispute Resolution Center, bodies which channel or put forth ADR by providing conferences, by providing education or training for members of society or the legal profession who wish to become certified mediators, as the case may be, or certified arbitrators. So there have been attempts, there are continued attempts to train and to educate members of society, but it still remains an area or a challenge for us in the Commonwealth Caribbean, because members of the community may still feel, well, the best option for them is to go to the traditional judicial system, when really and truly they may have an issue, they may have needs that can only be met via ADR, or only properly be met via ADR. So that's one challenge, definitely. And another challenge which we have is that of maintaining a certain quality and training of mediators in the Caribbean. Yes, the Mediation Act provides for the establishment of the Mediation Board of Trinidad and Tobago, and many mediators would approach the Mediation Board for certification. We even have a code of conduct for mediators to ensure that mediators are well trained and maintain high standards. However, for those mediators who are not trained in Trinidad and Tobago or seek certification before the Mediation Board, but who may practice in Trinidad and Tobago, they are not regulated by the same code of conduct. The other issue that we have, and I'm hoping that in time we can address this issue, is that of enforceability. So while arbitral awards are generally enforceable, for example, an arbitration award in Trinidad and Tobago can be enforced in foreign jurisdictions under the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards. And this it enhances the attractiveness of Trinidad and Tobago as a venue for international arbitration, and it provides global recognition, opening the doors for international business engagements here. The same cannot be said for mediated agreements then. Require additional steps to ensure compliance. So while notwithstanding we have court annex mediation in Trinidad and Tobago, which can lead to the court approving a settlement agreement for mediation and making it enforceable in Trinidad and Tobago. Unlike arbitration, we don't have anything that can say, well, these mediated agreements are enforceable in other jurisdictions. So those are some challenges that we are facing, but I'm confident that we are working towards improving upon them.
Yeah, fingers crossed. Thank you so very much for highlighting that. I also wanted to, we've not spoken about, did we touch on benefits?
No, we haven't.
Oh, yeah. So
Benefits got a manifold.
Yeah.
It's internationally recognized, and it definitely is something that's that we benefited from in the Commonwealth Caribbean, and it's the cost effectiveness of ADR. So mediation and arbitration are generally, because there is some scope for arbitration to become expensive depending on the nature of the arbitration or the parties or whom the arbitrator, whom the parties have chosen. But generally, they are less expensive than a traditional method of litigation.
Yeah.
They involve reduced legal fees and other associated costs. It's also time-saving. ADR processes are typically faster than court proceedings, and they help resolve disputes more quickly and efficiently. And I can attest to that personally, having engaged in court-annex mediation with clients who were in very tense situations, and within a year we were able to resolve an issue that could have taken 2 years because of backlogs and delays in the traditional judicial system. In fact, it took about 6 months or so. Flexibility is another benefit that we have that is universally beneficial when we talk about ADR, because the parties get to tailor their processes to specifically address their needs. And a major benefit is that of confidentiality. ADR proceedings are private, and that's something you cannot ordinarily benefit from in traditional court, which is normally open court, unless, of course, you are before a specialist tribunal like the Tax Appeal Board, or it's a matter involving a child, as the case may be. It's open. And preservation of relationships, of course, is key. Sometimes we can't preserve the relationship or improve it, but we can prevent it from getting worse.
And of course, have closure as well.
And of course.
Oh, thank you so very much. So you mentioned court-annexed mediation, and that's sort of, I thought about, is that the only mediation that parties to a conflict can use in Trinidad and Tobago?
Oh, not at all.
Oh, okay.
Court-annexed mediation is the type of mediation that is recognized by the courts. So if, for example, I am a litigant and I go before the courts for a matter involving the estate of my deceased relative, and there are disputes as to who are entitled to the benefits of the proceeds of the estate, then, and we approach the court, the judge before whom we appear may say, well, I think this is a matter that can be better addressed by an ADR mechanism. And thankfully, the rules provide for court-annexed mediation or settlement conferences. So let me refer you all to mediation. But outside of the traditional court system, parties can provide for mediation in their agreements. Parties can take it upon themselves to approach a mediation institution and conduct a mediation themselves. It's definitely open to them.
Thank you so very much. Sorry, you touched on something else that I needed to clarify. So, what is settlement conference and how does it work?
Right. So, settlement conferencing is another element or another ADR process that is provided for in the Consolidated Civil Proceeding Rules of 2016. It is a non-adversarial, cooperative decision-making process in which a settlement officer, such as a judge or a master or another person appointed by the Chief Justice, for the purposes of presiding over the conference itself, is assigned to conduct the settlement conference. And they will assist the parties in resolving their dispute. So instead of going to the courts, You can go to a settlement conference, discuss the matter in a non-adversarial way, and also be provided with assistance in the decision-making process in order to arrive at an amicable solution.
Thank you so very much for that. I was thinking about the laws and regulations that pertain to mediation and arbitration here in Trinidad. And of course, you've mentioned the CPR 2016 and the new Act, the Arbitration Act. Are there other laws that are new?
So the Arbitration Act of number 11 of 2023 is the newest piece of legislation currently, having been enacted in February of this year. That's in relation to arbitration. And it aligns with the standards of the ancestral model law and aims to provide a reliable and efficient alternative to litigation, or more appropriate form of dispute resolution. But we also have the Mediation Act of 2004, which formalizes mediation as a recognized method of dispute resolution. It defines the mediation process. It establishes the mediation board to regulate mediators, and it includes provisions for confidentiality and non-disclosure. It also grants immunity to mediators for acts done within the mediator process. So you can't have a party taking the mediator to court for negligence then. And it also contains a code of conduct for mediators so that the mediators act with a degree of integrity and ethics, and it also guides mediators in their practice. And of course, yes, as you rightfully reiterated, we have the Consolidated Civil Proceedings Rules of 2016, which encouraged the use of ADR, including mediation, as part of the civil justice process. So these are just some laws and regulations which reflect Trinidad and Tobago's commitment to providing effective and accessible dispute mechanisms. But there are others. For example, if I go into this, we'll be here all day, or even week.
Yeah.
But
I think I was about mentioning the community mediation that was revamped with the incoming new law.
Mediation Act, yes, definitely. Mediation Act did in fact revamp community mediation, and there are community mediation regulations which govern community mediation. And it's interesting because it all stems back, or it nods or provides appreciation of our traditional practices of community mediation. So it really is, I describe it as beautiful, but it's really dynamic in a sense.
Awesome. Thank you so very much. So I think you touched on the benefits, and when you talked about the cost effectiveness. So when you, as a practitioner and also a peacemaker, what is your take? Which of these two should parties, potential users, go for? Which is cheaper? And of course, which of them would provide parties, give parties a value for their money at the long run?
By when you say which, do you mean mediation or arbitration or the court?
Sorry, when you compare the traditional courts to ADR. Okay, so let's just put in ADR, but
generally speaking.
Yes.
What I will say is, I think it is dependent upon the needs of the parties and the circumstances which the parties are facing. Because while ADR is more cost-effective, reduces legal fees, and it's really geared towards preservation of the parties and their relationships, there might be certain cases in which parties require recourse to the courts. For example, where there's such a great power imbalance between the parties, and it's a matter that needs a court order, for example. because we know, in accordance with the Mediation Act of Trinidad and Tobago, it does not provide for mediation in respect of criminal matters, because that is the matter that is more suited for the courts. Currently, it does not provide for it. But otherwise, I think that, and of course, this is my opinion, I think that the ADR is something that provides a measurable difference when compared to that of litigation. And it's the ADR project, pilot project in Trinidad and Tobago, is evidence in and of itself of the measurable differences in cost and time frame for settling disputes compared to that of traditional litigation. Cost savings is a major one, reducing legal fees is another one, the faster resolution of disputes, participant satisfaction. I've actually had clients say to me, you know, Ms. Ramoutar, I'm so happy that we listened to you, that we tried mediation, that we tried to settle this matter, because I really could not rehash decades of hurt in a trial. So that was satisfying to me. It was very rewarding to me.
Yeah.
So I would say definitely ADR, parties should sit and think, what is the most appropriate method of resolving our dispute? Come together and say, what is the most appropriate method? It may not always be going to court.
Thank you so very much. And of course, this is a masterclass. And I also would like to add that, I mean, what would parties gain in going to court? Well, just like you said, maybe power imbalance, but apart from that sort of issue, I think parties would gain a lot, you know, taking their case to ADR because of all the benefits you stated herein, which of course supersedes that of litigation, you know.
Yes.
Litigation only encourages war, jaw, and of course ADR encourages people to talk,
Yes.
to sort of apologize and you know, minimize, and their frustration, their anger, their bitterness comes mellows down, you know, whereas litigation does the opposite. So thank you so very much for stating all these facts, and particularly the benefits and effectiveness of ADR. And I believe that potential users in the region would, of course, embrace ADR or select or choose ADR whenever the need arises. And of course, students that are sort of still thinking about, oh, should we go into full litigation, or should we, you know, go into this other route of peacemaking? Of course, they now have the correct perspective on those two dispute resolution, to the litigation and ADR to choose from to make their decisions when they need to make their decisions. But it's really I'm really glad that, you know, you say all this here. Thank you so very much for coming on the show, Chef.
Yes,
Angel.
thank you. I actually noticed, Dr. Maibolo, as Ms. Budu asked if there are new advancements in Guyana, and how remiss of me, because we have the Arbitration Act number 6 of 2024, which brings Guyana, just like Trinidad, closer to being a hub for commercial arbitration. So, Ms. Budu, Tiffany Budu, I'm so sorry, we missed this comment earlier on.
Yeah.
But definitely,
and also the eastern states of as well. They've most of them have implemented that in their new Supreme Court cases as well. So
excellent. Yes. So the Commonwealth Caribbean is so vast, and thankfully the region is advancing almost simultaneously.
Oh, okay. Thank you so very much. I don't know if there's any person that would like to ask questions. If not, then we're done for today. for today.
Hello, good day. My name is Farida McDougall. I'm a first-year law student at the University of Guyana, but I'm also a current mediator for the Upper Marlborough District Court. And I agree with a lot of the things you've said about mediation being a win-win situation for both parties because they're allowed to sit and discuss their case amicable, come to a decision that they would like for themselves rather than have a judge dictate for them what they should do. But did I hear you saying that as a mediator, you would have to give legal advice? Because in the US, we do not give legal advice. If they need legal advice and someone would ask you, well, what should I do? Then you refer them to a lawyer. You just facilitate the conversation between the two parties so that they can come to an amicable decision, as I said before. And mediation is really good because it helps with the load of work that the judges have to do and the courts have to do. And some of these matters are extremely simple. It's like fighting over a watermelon that went sour. They take the matter to court when all it needed was an apology because of the tone that somebody took that they didn't like, you know. So I'm happy to see that it's being promoted here in the Commonwealth Caribbean, and that is something that would help with the backload of people waiting to have their cases heard. Thank you.
Thank you, Farida. Actually, no, I cannot say that mediators, certified or otherwise, in Trinidad and Tobago can give legal advice. Mediators are not there for that purpose. Just like, as you said, in the US, mediators are there to facilitate the parties coming to their own amicable solution. So no, you cannot provide legal advice. I believe the example that I gave, which may have led you to that position, maybe when I referred to my client interaction when we engaged in court annexed mediation. Because apart from getting the court's referral to court annexed mediation, this is a party that is before the courts. So they will, of course, come to the attorneys and say, well, should I go to mediation or not? But from the time they decide to go to mediation, I cannot advise them on what they can do or what they should do. It is for them to take that action and for the certified mediator to facilitate them coming to that resolution of dispute. So thank you very much for that contribution.
Thank you so very much. I also would like to add that we've got different types of mediation, and I know the one using in the region is facilitative, but we've got evaluative where the mediators can actually advise. And some people in the States, mediators, they sort of they utilize facilitative and evaluative, and likewise any other mediator can decide to do that depending on what the case or dispute is. So we've got evaluative where parties can actually give their opinion.
Of course. And of course, once the parties agree to the evaluative mediation.
Yes.
So we're not saying that the mediator closer. The parties also have to agree to evaluative mediation.
Yeah, you're right.
Second question. Once you have this program growing, is there any follow-up educational training for these mediators?
I'm just to make sure
I ask is every month, as a mediator, every month we have continuing education. The code of ethics is extremely important because, like you said, confidentiality, whatever is said here stays here. It doesn't go up. You don't even discuss it with the other mediators. So I'm wondering, once this program gets its foot off the ground, will the mediators have continuing education? Will somebody provide continuing education for these mediators?
I'm trying to understand, which program are you referring to?
The arbitration program. Is this?
I'm not sure I understand. Which arbitration program?
Well, you're trying to implement arbitration, which is consists of settlement agreements, mediation, within the University of the West Indies. Am I correct?
Not at all.
Oh, okay. All right, then disregard my question.
Oh,
No, Farida, this is a research series of the Faculty of Law of the University of the West Indies St. Augustine campus, where we meet, we discuss areas of the law, we discuss some members of the academic staff will discuss their works that are in progress for the benefit of the wider community. But it's not intended, it's by no means intended to be a course that you take or get certification or like a professional course, as is provided by the Law Association of Trinidad and Tobago, where there are professional courses advertised and provided, or there are seminars that are provided for continuing legal education purposes.
Okay, understood. Thank you.
You're welcome.
okay. We have
colleagues, can I say something?
Sure, Dean.
Yeah, Dr. Alicia Elias Roberts here, Dean of the Faculty of Law. First, I'd like to say excellent presentation, guys. It was really a masterclass in arbitration. I really enjoyed it. And in relation to the question that the last attendee was asking, only this week I attended an arbitration conference at the UWI, and I met with a group that would like to do training in arbitration and mediation with the faculty. So I would tell the attendees to stay in touch, that you may see, programs and seminars and training coming out from the faculty in collaboration with other groups to train mediators and arbitrators in the region. So that is something that we have on our agenda, but it's not yet confirmed. But it's something we're keen, and this, as my colleague, Mrs. Ramoutar just said, Shivangelie Ramoutar, that this seminar is just a research series. So it's a free public education webinar, and we'll have it available on YouTube. But this is not any kind of specialized training coming under any act, any law, or any program for mediators and arbitrators. But nevertheless, persons are welcome to listen and learn. Yeah, so thank you for your attention, your participation, everyone.
okay.
Thank you very much, Dean.
All right, thank you so very much, everyone. Okay, so I'll stop recording now. I don't know if is there anybody that has any question or that would want to say something? No, okay. All right, thank you so very much, everyone, for coming. Thank you. Thank you, Shivangelie. Thank you.
Thank you very much, Dr. Megbolo.
All right,
Thank you.
bye. Okay, I could just pause.